Your Honor, good afternoon. My name is ChongWooPARK and I'm the counsel of the claimant General Granite. To present an argument of the legitimacy of this arbitral tribunal, continuing to hear the case, I would like to start by asking which substantive law governs the arbitration. As a starting point, the question where the seat, meaning the juridical seat, is located is therefore of importance when we look at the arbitration agreement itself. The applicable doctrine of separability allows to treat the arbitration agreement separate from the rest of the main contract. Thus, a distinction between the substantive law dealing with the merits of the dispute according to the main contract and the procedural law, as well as the substantive law applicable to the arbitration agreement dealing with validity, enforceability, and interpretation of the arbitration agreement, has to be first examined. We find in Section 6 of the Scotland Arbitration Act of 2010, which will I further refer as 2010 Act, that when the arbitration is located in Scotland, but no specific governing law is stated in the arbitration agreement, then Scots law will apply. This is supported in our case by English case law in the following cases where the seat was not expressively mentioned. The Dubai Islamic Bank versus Payment Tech Merchant Services in 2001, where the judge held that all the relevant circumstances shall be considered, which included especially the parties, where they are from and where the arbitration is situated. My client is Scottish. The venue and the authority selecting the arbitrator are in Scotland, and the arbitrator will be likely Scottish too. Second case I would like to mention is the Shashwa versus Sharma 2009 case, where the judge held that in the absence of the express designation of a seat, but with the designation of the venue becomes the seat. Although in that case, the substantive law of the main contract was Indian law. This is somehow similar to Section 6 of the 2010 Act. In conclusion, the 2010 Act forms the substantive law applicable to the arbitration agreement in conjunction with the procedural rules of the UNCITRAL arbitration rules, which I assume to be of version 2010. Accordingly, as there is a valid arbitration agreement, there is a dispute, and this dispute falls within the substantive scope of the arbitration agreement, and the arbitrable tribunal is properly constituted, then the mandatory rule 19 of the 2010 Act grants that the tribunal to rule on its own jurisdiction following the competence doctrine. I would like now to review a second point on whether the arbitration procedure has been properly initiated. That is, whether a notice of arbitration has been served in order to initiate the arbitration. As a related point, I will raise the question of a joinder of the third-party abacus to this arbitration. Arbitrations are private. This is one of the reasons why parties choose arbitration over litigation. The fact that the subcontractor's counsel has deliberately attended today's hearing seems to be not an accident. There are two main things we can learn immediately from this fact. First, that the delivery of the notice of arbitration has been received by Mr. Twiggins, although there was never a response. Second, that abacus are represented by its counsel, although subcontractor and non-signatory to the main contract, shows interest in this hearing by attending today. And despite expressing being here neutral and disinterested, they argue at the same time to stay this case. Although my client did not know that Mr. Twiggins was mainly employed by Abacus at the time of delivery of the notice of arbitration, and thus was not the authorized person to receive the notice, Article 3b of the UNCITRAL rules sees a notice deemed received if it is delivered at the place of business. And Mr. Twiggins was the main contact at the daily place of business, and no other contact was given. Furthermore, one would expect from a reasonable and prudent subcontractor that, besides the regular communication with the client, such notice of importance as the notice of arbitration would have been forwarded with highest priority to the client, especially by someone with Mr. Tweegen's own interest having a backup position with Mighty. At this stage, our position is to ask the tribunal to consider deciding on this matter in a holistic view of equitability according to further arguments to come, and finally resolve this controversy according to Article 3, subsection 5 of the UNCITRAL rules under its own discretion. What we also learn from the attendance of Abacus Council is Abacus' intention is not only to be a neutral and disinterested party of this arbitration, but to influence the proceeding itself. As the party who was de facto contracted for all works and should be therefore in dispute on the merits with my client, Abacus advocates now that the case will not be continued. Our position, therefore, is that this is a clear implied consent by Abacus to be part of this arbitration. Another argument for joinder of Abacus to this arbitration is based on the equitable principle. In Scots law, an arbitrator can decide in terms of general equitable considerations known as ex equo ad bono. Thus, where adding an additional party places a minimal burden on the original parties and the risk or expense to an existing or third party of not permitting joinder is high, the arbitral tribunal should strongly consider letting the third party into the arbitration. The test for equitable factors in favor of permitting a joinder will include 5 points. First, the common issue of law or fact. Second, claims arising out of the same transaction. Third, significant or irreparable harm to an existing or third party if joinder is refused. Fourth, existing of a contractual link between an existing party and the third party. And fifth, recognition of a third party rights or interest, such as a third party beneficiary in the original party's contract. Most of these tests are obviously fulfilled in our case. Regarding the first test of common law or fact, our argument is based on Scottish case Bruce versus Codula 2001, where uncertainty in the wording in an arbitration agreement was the reason for its invalidity. Looking at the wording in the UK in Abacus subcontracts arbitration agreement is therefore sufficient enough to hold the arbitration agreement invalid, as UK could mean England and Wales, Scotland or Northern Ireland. As the fallback law is then the governing law, Scots law of the subcontract, it would be in line with this arbitration and the same provisions can be applied. In particular, the last test related to the third party beneficiary is important. The Scottish law recognizes the principle of jus quaesitum tertio. In Scotland, all promises intended to create legal obligations are enforceable by those in whose favor they were made, where it is proved that the object of the contract was to create such right. The wording in the subcontract consenting and referring my client as ultimate beneficiary of the project is a plain recognition of this right. And our position is to enforce our right and interest to resolve the dispute and complete the works immediately without any further delay and unnecessary expense, with a counterparty that has been subcontracted for all works and is represented today at this hearing. We add that the substantive law and the rules of this arbitration would allow for a joinder according to Section 4 of the 2010 Act and the Article 17, subsection 5 of the UNCITRAL rules. Your Honor, I know that my time is running out short, so I sum it up now. We would also like to emphasize that in the interest of efficiency of arbitration, the cost, time, judicial resources of having multiple hearings in two arbitrations about the same issues, risk of or likelihood of inconsistent awards, we request first the joinder of abacus based on equitable principle and shown implied consent. And second and final, continuing this case with abacus in order to resolve the dispute without further delay. I'd like to thank you, Your Honor. Thank you very much.